judiciary has evolved through case-made law. Our judiciary is not a toothless tiger. They know what to do. They can evolve. Rapidly. They did that. You should not get deviated from all of this. What your friends are doing, how happening their life is. So that opens a Pandora box. Every losing lawyer, there would be a case, unless there can be a threat also, which can say unless you don't file an appeal with lesser fees or with no fees, I would file a consumer protection case. We would only be a puppets in the hands of AI, applying a little knowledge here and there. We'd make some corrections. Don't subscribe for Netflix, have subscription for Hindu or Live Law. So we cannot expect a judge to be a politically innocent. Obviously, he would have his political ideas and ideologies. You cannot expect that.
So I would like to begin by quoting our Honorable PM. ये पवन सर पवन नहीं, आंधी है आंधी. He has swept us all off our feet with his hard work, passion for law and achievements. Pavan sir is an advocate, lecturer and junior research fellow. He has in the past cracked the CLAT PG exam with All India rank 97 and completed his LLM from NLSIU Bangalore. He was presented his LLM degree by the Honorable Chief Justice of India, Dr. D.Y. Chandrachud, and was also awarded gold medal for best LLM dissertation instituted by Messrs. Sitaram Jindal Foundation and gold medal for comparative public law and governance instituted by the prestigious Nani Palkhiwala Memorial Trust. He has cracked the UGC NET in his first attempt and is currently a research fellow at Usmania University College of Law. He has written more than 35 articles in various journals, newspapers and blogs. One special article that I would like to highlight in this regard is a comprehensive analysis of judicial legislation in India, which he co-authored with respected Professor G.B. Reddy sir. So this article was selected as reading material for newly elevated High Court judges by the National Judicial Academy. Apart from all this, Pavan sir is also the Vice President of an NGO, Vriddhi Bharat, which promotes legal awareness. He has founded the lawreporter.in blog as well and mentors a lot of law students. On a personal note, I would like to add that my first article was published on his blog, and the first legal competition that I attended and participated in was organized by him through a platform called Legal Lounge during the COVID time. So thank you sir for joining for the interview, and we are delighted to have you here.
Try to be, that praiseworthy. Reach your.
So sir, first of all, we would like to know the journey behind all this.
I think the journey started in 2016 when I started preparing for CLAT UG. So there was no guides or mentors for me as such. Even though my father was in the legal field, but he was not actively practicing then, and he was not well aware with the National Law School culture and all that. So he was like, chalta hai, you need not to prepare much, it's just another exam, you will crack it. So after my first year of my 11th standard, to say it so, I secured highest marks in my college. So there was a pressure from my college to join CA because they thought that is the best option and I could easily crack it. But then I was firm that I have to do law, and I was interested in law. So from second year, maybe from August to September, I started preparing for CLAT on my own. Then I gave my first attempt and I got some 1200 rank, and I secured a seat in National Law School Kochi. But then as the fate turns, I did not join that institute, and I thought that I have a bigger college in my fate, and I thought Nalsar would be the college. If I drop in here and join prepare for another year, I could secure a seat in Nalsar. But I didn't get that through also. So my father insisted me to write, in the first attempt when I was just intermediate, law set also. I had a very different view that who would write this law set, state colleges, this state college, who would join these state colleges, I should do my LLB from National Law School. So I said to my father that I am writing law set, but I didn't apply for it, and I've written it in I've written LSAT. I said that while my father was dropping, I said this is a law set exam, but ultimately it was an LSAT exam. When the results came in, my father was very angry and furious. Why didn't I apply for law set? Subsequently, the year got wasted, and second time I secured in NLU Odisha. But I thought better than that I'd pursue my law in Osmania University, where I got state third rank. So I thought my family was also a little bit happy and got over the 1 year which I wasted. Then I quickly joined my college at University College of Law, Osmania University, with lot of dreams as any other law student. But things were quite different there. It was more of self-learning, but I found a few great lecturers there who helped me a lot in my journey. That's how I first entered into a law school, through a law set exam, where I got I secured a good rank, and I joined my university. That's how it started.
So sir, you mentioned that you had taken a drop year. So what is your advice to other students who are doing the same, who are trying to secure a seat in the national law universities? Should they give the law set exams of their state as a backup? What should they do? Is NLU that necessary?
So the same question was asked by me, my students also, where I train for CLAT undergraduates. Last year I taught for them, and many of my students are at National Law School and Nalsar. So some of them who are brilliant but could not get into the college, they thought it's worthy. Some took a drop, some did not. So the factor is how disciplined are you, whether you can wait that 1 year, prepare that 1 year, or it's a very difficult. When I took a drop, it was very difficult for me, because my friends joined in various engineering colleges, my peers got seats and I could not, and my health was also not good in that 1 year, where I had a problem with my knee and I could not walk. I had to take rest for 2 months, bed rest, and this was all playing in my mind, and I did not have any group to study also. I was studying alone, and for a 17-year-old, 18-year-old, it is not easy to sit alone in the home when your parents are not there. You watch some YouTube videos, this and that, GK, this, it's not easy for them. So my advice would be very simple, that for at least state specific, to our states, Telangana, Andhra, I would say that if they can get a seat in local college, especially like university or some Pendekenti, Padaram, any other college, they should first join that, and then they should start preparing, because point number one is that in the first year the academic rigor is not that much high in the state colleges. So as a matter of fact, you can balance both of it, because the exam CLAT is nothing about remembering, but it is about comprehending and your ability to read the entire paper and answer the questions. That is what it matters. So that could be even achieved by not wasting that entire 1 year, because that's my personal experience, but I won't regret wasting that 1 year. At the looking at that time, I learned a lot. I've gained a lot of courage, a lot of understanding about myself, law and all that. That eventually helped me getting a good score in law set undergraduation. So that's fine. So there's no straitjacket formula for everyone. But if you are a 17-year-old, 18-year-old listening, and you can't sit for a long time and study 8 hours at a time, 9 hours a day, then I think it's better to join any other law college or a degree college, and then put this as a main goal, and then start preparing for that. But there is a threat for that also, because if you don't crack it the second time, then what is the path you have to follow?
Yes.
Honestly, it's a do or die situation for you. If you are taking a drop, and if you have joined some local college which is not good, but also second time you can also write the law set or other exam repeatedly. You can upgrade your college if you think that. In Hyderabad, I can say University, Pendekenti are two good colleges you can blindly join. So as far as you are in these two colleges, I mean, you are at least safe to the outside world. Outside world's perception, you are safe. I'm not saying these two colleges offer the great best law education, but these are, available best choices. That's what I can say. You can also write law set again. I mean, there are MH set is there. You can join ILS Pune. You can join Government Law College Bombay, which I got, but I didn't know that university is such a great university. After then I realized I missed a great opportunity. So there are lots of opportunities. So it's important for you to get some mentors. There are a lot of colleges. Delhi University is there. It's a great college. Lots of private colleges also there. If you can afford, you should definitely choose private colleges. Symbiosis, Pune, Hyderabad, ICFI, IP, Dehradun. These are all great colleges. I mean, no doubt about it. Yeah.
Sir, you have mentioned that your mentors guided you a lot. So according to you, what is the importance of having a mentor as a law student?
I always felt like Ekalavya in the first 3 years of my law in my 5 IDC, because there was no one to mentor me. Because we were all in a fun mood in the first 2 years, where honestly I didn't study a lot in the first 2 years, where we were coming to the college after classes. We used to roam around, not sitting in the library and studying some important things. So my first mentor, if I have to say, that would be Professor GB Reddy only, because I wanted to write an article with him. I was very reluctant, very hesitant to ask him, sir, second year bacha videnti. I mean, he's just a second year. I mean, he's a great lecturer, and I can't directly go and ask him, sir, I want to write an article with you. So I started giving him sort of hints that I used to write up and show him. I used to correct it. You should write this, like you should change this, you should change that. Then I slowly started, I participated in a Moot, KIIT Odisha. So there I got my first taste of, how competent I am amongst the National Law School students who came there from different national colleges. So I understood my position, where I stand. Then I started working on myself a lot, started reading a lot. Then I started slowly writing articles and then showing it to Professor GB Reddy sir. So one fine day I was like, I couldn't stop myself. By then I have published like 2-3 articles in few journals, but not great journals, and one newspaper article. Then I met sir, and sir, I wanted to do an internship under you. This was just before COVID-19. So he was like, Pavan, I know you are exact words, you are competent, but what will you learn under me? Sir, I said, I don't know, but I wanted to do an internship under you. Please give me an internship. So he readily accepted, and he started giving me articles to write for. Articles. He gave me some ideas on how I should write an article. He gave me broad topics. Then I started writing articles. One was on cyber crimes. Second was on judicial legislation, which I wrote. Then third, we've written an article. So third article was the first article. So when I showed him, he readily said, okay, let's send it to a newspaper. So I was like very impressed and shocked to see that. When I spoke to other seniors who wrote with him, they were all like, no, he wouldn't give that chance to me. They were like, you should not ask. It is better you don't ask. So I was disappointed, but when I written an article and shown it to him, and he was like, okay, Pavan, do these changes, let's send it to Deccan Chronicle. So I was like very happy at that point of time, and I sent it, but that didn't get selected. So it's okay. But after that, when I worked really hard on judicial legislation article, that was in 4th year. It took a lot of time, lot of research. It was over 10,000 articles. That means LLM level PhD, not LLM level dissertation. 10,000 articles, 10,000 words. So he was happy. He made few suggestions, and then we sent it. And I didn't know that it got published in SEC online. That's fine. It's not a big thing back then. Then after that, this is how he started guiding me. After that, when I was in my LLM, suddenly I was searching one of my articles, and this article popped up, and then I came to know that this article was selected to as a preferred reading in NJ by National Judicial Appointments Commission. So then I was, I can't describe it. Then I informed GB Reddy sir. So GB Reddy sir is my first guru who helped me. He's my mentor who initially helped me a lot. Even now he's my guide in my PhD. So he helped. I mean, I can't say much about him, but that's it. He helped me a lot.
So sir,
I can see in your eyes that you missed. I think your eyes are communicating to me that if you are in university, you would have got the same chance, and you would have asked GB Reddy sir regarding. You would have taken my position, and I can see from your eyes.
No sir, I am satisfied with how my law school journey has planned out, because I have so many articles and participations, etc. I am happy with doing that. That was also a big challenge for me, because I have faced the same problem as you. First 2 years of my life, I did not know anything. I did not know that internships, that a thing like internships was there, that a thing like article writing was there, that competitions were there. Because of you only I had that exposure. So my next question is, why do you think there is lack of exposure in law colleges in Hyderabad? I don't see this problem in other states.
The first and foremost thing is that the curriculum is very old. It is not rigorous. I mean, you cannot attend 90% of the classes, but still pass the exam. That is the major problem. But after spending 1 year in National Law School and seeing 5 IDC students, I mean, they die every day to survive there. I mean it's terrible, it's horrible, but they learn a lot. I mean, even for an economics paper, they sit and study for like whole day. Even they don't sleep the entire night and write the exam. But it's not the case with respect to our curriculum. But that is the major thing. Curriculum is very bad. The teaching is old-fashioned. There are no proper professors, teachers, if I have to say. I mean, some of them don't have this exposure, and the different teaching styles. It only goes around teaching the subject as just subject heads one by one in the syllabus. That is the major drawback. And not giving enough assignments, not having enough marks with the teacher to grade. If there are, when I was pursuing my LLM, 50% of marks were with the professor who was teaching the course. So it is very difficult for a student to not attend the class, to not buttress the teacher, to not submit assignments, to not give presentations, to not write articles and then getting good A. It is not at all possible. So you have to be present in class, you have to submit articles, you have to make presentations, you have to read notes, you have to be there are even marks for class participation, 10 marks. It is not that in our state, in the syllabus. So that is one such thing. And another thing is, especially with 5 IDC, I think that age criteria should be there, age restriction. You can't make a 18-year-old guy sit with a 30-year-old guy, and 15% are 15 to 20% are about 25 years, 28 years, just coming to the college for this is just another degree for them. So that level of competitiveness gets down when there is a lot of diversity in the class, especially with respect to age. That is a problem. Then another thing is, as I said, not having the marks with the course instructor. That is an issue. And the paper, you see, our question paper is, if you just read 10 question papers and just go and write the exam, that is fine. You'll be able to pass with the flying colors. That is the situation. So curriculum has to change. And apart from that, when you say exposure, students are also, because the curriculum is light, students get deviated to other stuff, especially bunking the colleges, right? And the level of practice in the, I cannot say that, but especially bunking the college, seniors not able to guide properly. In the first 2 years in my college, seniors are also did not have that exposure so that they can guide me. That is an issue. That is the main problem.
Sir, have you heard the term one-day batting?
Yes, yes, I did it many times. I am also guilty of that.
Yes, sir. Me too, I guess.
But not after LL. But see, I mean, there are few students who do that. But for me, when I was in college, I won't suggest students to do that. But I used to, every semester, I used to get excited about few topics, few subjects: constitutional law, evidence, public international law, criminal procedure code. There are few subjects which I like the most. So I used to read only those subjects from different books. Rest all subjects I used to do one-day batting. So that worked for me because I only focus on few areas. So I mean, ultimately, I won't suggest you have to have an entire knowledge of law subjects at least at that level. But later I regretted that. When I was studying for CLAT, I had to read everything: contracts which I didn't read in the first year, torts, some basic subjects, again jurisprudence, from again the same problem in my UGC JRF also. I have to read these subjects I didn't read in my, had I read that in the first year, second year, or I would have been benefited a lot, but you would regret at the later stage if you don't read it.
Yes, sir, that's. Sir, you have written more than 35 articles. I think you have written more than 50, but you have not updated your LinkedIn, I guess. So LinkedIn shows about 35 in prominent journals, newspapers and blogs. So what is the benefit of writing articles for law student? How do you research? How do you choose topics? How do you publish articles so consistently?
I think joy of writing that I enjoy it. Before ChatGPT and all, I am happy to say that I started writing before ChatGPT. So I have some writing skills. People can at least say that. Before my LLM dissertation also, there was no, after LLM dissertation ChatGPT came into picture. I am happy for that, and I loved writing it because I used to read a lot. So I used to follow a technique where I used to read one entire journal article, then I used to just keep that aside and frame my thoughts, and then I used to start writing on my own. That helped a lot in my academic writing. So how do I am so consistent? I just like writing, so I write it. That's it. There's no answer.
I heard that you wake up every day at 5 a.m. and write article. Is that true?
Sometimes I do, but nowadays I'm not, because of my other commitments, I'm not able to do that, and my guide is also angry on me for that. Yes.
Yes, sir. And what is the benefit of writing articles for law students?
See, if you write an article, there is a 100% chance, there is a 99% chance that nobody would read it. But if you don't write an article, there is a 100% chance that no one would read it. So you are expressing your views to the world. So you won't get a platform like this unless you are, no one would listen to you unless you are a good article writer or a newspaper columnist or something like that. You won't get the platform so easily. This is a privilege that I am having, able to speak to you in this podcast, in your with so many subscribers you have. It is not easy for that. The easiest way is to write an article. Okay, if somebody would read it or not, that is a different story altogether. But the benefit is, one, you can, when you go into academics, that would help a lot. Two, when you are especially stepping LLM, if you are doing an LLM, our college, our university, our curriculum does not have requirements of writing an articles and submitting, but different colleges do. Three, when you are into profession, your drafting skills get improved. That is a major, positive to look at. A lot of lawyers in Telangana cannot draft. That's the biggest problem they face because of the curriculum itself, because of the college itself. It is not because of the background they come from. If you are having good background, if you are able to read journals, should at least give it a try. That is what I say. It is not compulsory. If you just want to be a lawyer, yes, you can just restrict yourself with the plain drafts and all. But if you want to do something more, even a lawyer has to be socially conscious about what's happening. I mean, he's the first protector, as to say when the things are not correct. He has to speak out first, and especially when it comes to laws, he has to be the first person who respond. Then academics also. Academics and law. You can be an academic lawyer also, like Rajiv Dhawan sir. how many articles you have written it. I mean, I've read so many articles. I mean, wonderful. You should. That's also a stream of lawyering. You can do that. You can teach also. If I feel very proud when I give my articles to my students and I teach upon that. I mean, I used to do that. It feels nice to do that. So you can do that also. Yeah.
Sir, as we all know, you have cracked some of the toughest competitive legal exams out there. We would like to know your suggestions and advice and the strategy behind strategy for this competitive exam. Can you break down these competitive exams such as CLAT PG, UGC NET, Supreme Court Legal Researcher, etc., and give your advice for the same?
For CLAT, I think the paper pattern is ever evolving. So whatever I prepared then, I can able to tell only that. So whenever my juniors used to ask me, I only say you should follow Trinity. 1, the provision of law. 2, the provision which is in controversy. 3, the landmark judgment on that particular provision or an issue. Focus only on this Trinity and just read upon only these things. This is what I used to suggest them. But fundamentally, you have to be equipped with core subjects like Constitution, criminal law, public international law, and then contracts and IPC. Contracts and all. But previously, I mean, the just preceding year when I wrote the CLAT, they even asked criminal procedure code. So for that, I have to start reading criminal procedure code. They asked one passage from IBC. I read that also. So there's a diversity in the question paper. You can't expect that. So you have to be well equipped with the core subjects. That is what I can say, especially jurisprudence and all these subjects which are helpful for academics. So once I entered National Law School, when I reviewed the paper pattern and all that, what I understood is that they are only trying to check the level of comprehension capacity a candidate would have. This is the only criteria they are looking at. So you can see the question paper is becoming lengthy day by day. Unless you are not a quick reader, you can't grasp the entire question paper and solve it. So for the first thing you have to do is start reading newspaper right from the third year itself. If you're doing it, I mean, if you should start reading newspaper right from now also, because when we were in law school, we used to write letters to the Chief Justice of Telangana High Court to consider this as a public interest litigation, and he even considered 1-2 matters like that, especially my letters. So reading newspaper would always helpful to you in any way, because I need not explain why reading newspaper is important. That is reading newspaper, quick reading. You have to get the habit of quick reading. 1, then some foundational subjects you have to focus on them. Then at the end, maybe in the month of, if the exam is in December, start taking mocks from the month of September. Try to be competitive amongst the other participants of the mock test exam. You have to be competitive, you have to read a lot. But when I started preparing for CLAT, my only motive was, I was always wanted to practice. My only motive was, I used to tell to my friends also, I wanted to be a complete lawyer when I step into the court. That is the reason why I am preparing for CLAT. So that helped me a lot in terms of knowledge gaining. Not for exam itself, I started reading so that just for the joy of reading it, because I did not do that in the first 2 years. In that way I learned, even if you don't crack CLAT, you will have a lot of knowledge about latest case laws. I still have a book of 2021-22 landmark judgments where I used to note. So they are still relevant now. It is not that, 2021 they would always, for the 1 year you have live law, you have subscription. If you have a subscription, then you will be equipped with a lot of, provisions of law, key legal points. That would help you even if you are just entering into practice. So what was your question? You were asking me how to prepare for CLAT or how to crack CLAT? Prepare and crack. So cracking CLAT is always, you can't predict it, because my rank was, it's a very tough exam in the sense that if you have to be in the top colleges like Nalsar and National Law School, you have to work really hard and get a good rank. And when I was writing CLAT, I mean when the results came, my mark was around 73 point something change. I got 97th rank. The guy who got 81st rank also stands with the same mark. So you can see on the same 0.25 there are around 14-15 members. So that is the level of competition that's prevailing for CLAT PG. I mean the seats are also low, and it's no point in doing in other in small, I mean not small colleges, not in the top 3 NLUs. So it's better you do in the top 3 NLUs or just do it from some other random colleges. It's no point. You wasting the entire 1 year going there and staying. If you have to do it in National Law School Delhi, so National NLU Delhi or National Law School Bangalore or Nalsar, or else don't do it. West Bengal is also good, you can do from that. For cracking CLAT, start preparing early, which I didn't do it, which I regretted a lot, because at the later stage I thought that I could, even if I prepared for 1 month more, I could have been, had a good rank and all that. But start preparing early itself. That is what I say to my juniors. Start preparing from January itself. What's harm in doing that? I mean, it's not a pride to say that I prepared at the last moment and I got this rank. That is not a good thing. So start preparing. You will get a good score. If there are any seniors you have in your college, contact to them. They would be willing to help. If not, you can contact me also. I would also be grateful to help. And be disciplined. You have to every day put in hard work. That is one consistency. And Neha ma'am helped me a lot. Neha ma'am and Tarini, I call her Tarini Akka, she's a junior civil judge in Telangana. So they both helped me a lot. I mean, one advice both of them gave me is that if even in a worst day, if you're not willing to study, at least study 2 hours on that day. So that one principle I followed, even on those days where I don't want to study, I still picked up the book and at least read for 2 hours, or at least scrolled Live Law for 1 hour and Supreme Court Observer for 1 hour. I used to do that. So that helped me a lot. Yes.
Sir, coming to UGC NET, what would be the strategy advice for that exam?
Read for CLAT first. The same thing would come in UGC NET. So prepare for CLAT. It's kind of a same question paper pattern for, not same question paper pattern, but the same knowledge it would be useful for UGC NET as well. Law paper, I mean mostly the same major subjects which are there in CLAT that would be repeated in UGC NET. So majorly I didn't have the time to prepare for UGC NET. Because my foundation was good in CLAT, I was able to crack UGC NET. Because in NLS Bangalore it was a tri-semester. So there was no semester break as such. I had to prepare while the semester was going in the rigorous schedule. I had this one goal while I wanted to crack UGC NET in my first attempt. Or else I thought, okay, done, I'll be joining profession. So that was my goal, and I used to, whatever I made notes for my CLAT and PG, the same I revised. Then I found some useful books like A.K. Jain, where the subject was very concise and I could have revised it very quickly. I did that. Then I started reading all the previous question papers. Paper 1 is important, where I scored very less, so I cannot be someone who can guide you on that. I think I secured some 28 or something in paper 1 from 50, which is very low. People those who crack UGC NET generally get JRF generally get about 38, 39. I got only 28, but I covered entirely in law. I got around 89 or something out of 100. So that helped me to crack UGC JRF. So my foundation in law was good. So I was able to crack UGC NET. But if that is not the case, you can attempt every 6 months. So you should not get disappointed by, if you didn't get in the first attempt or second attempt, be knocking the doors every time, because there is a pinch of luck you have to have for cracking UGC NET, JRF especially. Because in general category, I was the last mark in the UGC JRF NET. And when I was writing UGC JRF, the cutoff was the highest of all of ever. It was 236. So mine was the last mark. So yeah, you have to have luck also around you, but you have to be persistent with that. Consistently you have to study every day. Then there are few materials also online. You can KS Madan's material on paper 1, that would be helpful. It's a free PDF. I didn't purchase any other book also, I just read from that. People can say that's why I got less marks in paper 1, but I only read from online sources. Yeah.
Sir, do you think the legal competitive exams are becoming more understanding and application based?
Legal competitive exams, yes, in a way. Apart from state exams, you can take JCJ, you can take law set, you can take any other state exam. They are not application mind. But apart from that, JAG, CLAT, Supreme Court clerkships exams, all are application based only. So I'm only saying this thing, that the curriculum here is bad. It has to be changed, and it would change soon. I am sure it would change. The things are under process and it would change soon. But you have to also have faculty who are ready to do some innovation with the pedagogy, the kind of teaching they have. That should also be there, because you can't just explain basic structure without, part 1 is the Article 13, part 2 is 368. You can't teach Article 13 without teaching 368. You can't say I'll teach 368 in the second semester. So you should not just be restricted to what you are teaching. Just to the classroom and to the portion. Application based, yes, that would help. That would be helpful when you even practice also. So that's why I tell my students also, join internship at the second year itself. There is no harm in joining internship at the second year. Let's say if you do 5 internships, if you're God bless you, if you're lucky, you would get one mentor in the 5 internship. He would help you lifelong. That is for sure. If you just make that one mentor a good friend of you, then that would help you a long way. So do internships. Just don't do it for the sake of getting certificate for 15 days, 20 days. Not even the attender would recognize you there. So you can't expect a lifelong mentor for you. So you have to do an internship for at least 4 months, 3 months. That is the minimum time. I would say 1 month internship it's crap. I don't think that should be even recommended also, because the senior would only talk to you when you are appearing daily in his office. He would be busy with all his matters, so he would just give you some research work. But once you are there, he would understand that this boy or girl is sincere, and he would slowly start you involving in some discussions. That is what I would say. From that you can learn the application. If you're practicing, obviously you have to learn application, right? If you're even interning, you have to learn application. Why do you draft a 482 quash petition? You have to understand it. What is a discharge petition? You have to understand it. What is interlocutory application? I understood after my 5th year. After even learning CPC, I could not understand it. Once I started entering civil practice, then I got an overall view of it. So yeah, you have to intern. That is one such thing. You have to all students have to focus.
Sir, we are living in the age of social media, content and entertainment. There is so much entertaining content out there right now that even 10 lives won't be enough, I would say. As we all know, the content is so addictive that it is very difficult to stop and limit its consumption. I myself have blocked the Instagram Reels and YouTube Shorts right now. My question is, how do you stay focused in this entertainment overloaded world? How do you stay consistent?
Whenever I'm preparing for exams, no Instagram, no only WhatsApp, nothing, no Facebook, no, I don't have Snapchat, so no, I don't know what it is also. Only I have WhatsApp for communication, that's it. So even then, when I start my semester to teach for students, I just remove my Instagram, so that you eventually spend 1 hour without knowing what you are doing it, and your brain gets kind of foggy after looking at the Instagram for long periods of time, and you can't focus on reading. So I say just have it for entertainment, for once, if you are looking for, you can just install it once in a day also, if you want to do that, and just look for 10 minutes and delete it. But especially when you're focusing on exams like judiciary, CLAT, UGC NET or any other exam, UPSC, it's a big no-no. You should not have a. I mean, you can. There would be stories who still have people who still had all these things and then cracked. But I would suggest, because you should not get deviated from all of this. What your friends are doing, how happening their life is. It's better to not have all of it. But yeah, I generally don't have Instagram. Now also you can check my phone. There's no Instagram. So that's because that time you can at least read one article, one live law article or newspaper. It would be so refreshing. I mean, reading is always, it would help you a lot. That's what I can say.
Sir, what is your opinion on the new criminal laws?
New criminal laws. I can't say well versed with everything, but I can only, after teaching also, just because I got an opportunity to teach at different audience, so I can only say about Bharatiya Nagarik Suraksha Sanhita, which is the new avatar of criminal procedure code, which I always interested in. So it is mostly, there is a 2 to 3% change. Everything else is renumbering and restructuring and resequencing. Nothing much has changed. Whatever few landmark judgments were there are inculcated as provisions. Let's take 0 FIR or EFIR, 0 FIR. It was previously there, but now it is in a provision wise, right? People were previously serving summons. Few state governments are allowed serving summons digitally. Now it is there, but there are few additions also, which are really helpful, which are really good. But the entire inertia of learning some new subject, especially when it is very difficult for us. Murder means 301 or 300. Now we have to remember 101. Rape is 370. It's 72, 74. Entire relearning is very difficult, especially when we have mugged up all the provisions so hard for our exams. And there are certain provisions even if I wake you up at night, you will be able to answer it. That inertia is there, initial inertia. I think in the next half a decade we'll get over it. But old CRPC is also important, because all the previous cases, whether it is investigation, inquiry or trial stage, they are all bound by previous CRPC only, except the new after 1st July the new BNSS applies. So you can't discard old CRPC, because our criminal justice system, one case runs for 10 to 15 years, and there are cases which are pending from 2002. So you can't just throw away the new CRPC. There are pros and cons. Do you want me to enumerate few pros and cons?
Yes, sir. Sure.
Pros and cons. So kind of citizen centric, victim based. There are few provisions which are helpful to victims, like let's say supply of copies. Previously it was only for the accused, now it is for the victim as well. Then you have to keep the victim in the loop of the investigation. You have to inform within 90 days what is the progress of the investigation. Then especially when a committal case is there from sessions, a victim can file an application, but it didn't go much long. I mean, it did not help victims much further. It stopped till there only. Like now, even now, new BNSS victim can only assist the public prosecution, but not fight a case against with the prosecution or help prosecution in filing different applications and all that. That is not there. Case laws are there which says that in 302 you can do that, but that is not inculcated in the new provision, in the new in the new BNSS. Then when it comes to police, certain powers, obviously they have more powers now, especially when you read 107, section 107, when it comes to their search powers, custody powers. Now they can have the custody for till 45 days. I mean, not till earlier it was only section 167 of CRPC says that custody is only for the first 15 days. It does not enumerate it, but the case laws are there. Anupam Kulkarni and few Supreme Court judgments say that only first 15 days you can have a custody of an accused. But now the new BNSS 187 says that you can take that first 15 days in the first 45 days when it comes to the remand of 60 days. Similarly, with remand of 90 days, you can use that first 15 days in the first 60 days. Few powers of police are more now. There are few other provisions also which are not currently striking to my mind. Bail provisions are kindly somewhat stringent now. It is difficult to get a bail, especially when you are a second time offender, or if there is another investigation inquiry which is pending against you, or previously bail was not granted in cases only with death punishment. Now it is death and life imprisonment as well. So that is a problem. But there is a beneficial provision also which says that for the first time offenders who are under trial, who have completed 1/3 of the punishment, can be released on bail, and that bail would be applied by the superintendent of jail himself or herself. So previously it was only the concerned person or his family members used to apply. Now it is the burden on superintendent of jail to do that. It certainly helps in preventing overcrowding. Then subsequently we have a landmark judgment. I think it is not inculcated in the new BNSS. It's a missed opportunity, I would say, which says that the magistrate or the concerned judge who has granted the bail has to suo motu take the cognizance of the case if the person is not able to pay the surety amount after getting the bail. So such provisions and few landmark judgments are there that were not inculcated. If they were inculcated looking at a different angle, state would be benefited, because per day they are spending per month they are spending around 7,000 on an under trial prisoner. These are provisions which would help in decrowding prisons. At the same time help our idea of reformative thing. It would help our Indian judicial criminal justice system also, and would put our country in a different light. That those were not inculcated. But even though when Amit Shah said that this is all, we are breaking the shackles of colonial mindset and all that, but ultimately we have copied and pasted most of it. Is if you do a plagiarism check, you will get 95% the same old CRPC and new BNSS is same. But the thing is, I have a big problem is with this renumbering, that most of the judges would find it difficult, because why would a judge at the age of 50 would try to read it? He'll just push it under the rug. Obviously there are judicial trainings and all that which are going it, but yeah, lot of books which have to be discarded after a few years. That is a big problem. When it comes to negatives, again there are more positives also, focusing on electronic evidence, search and seizure, individual liberties, especially search and seizure. They be compulsorily, the word uses shall. When it comes to search, the police officer who is doing the investigation shall record the evidence. Through audio, shall record the search through audio or video form. That is one big thumbs up for us, because illegal search can be prevented and planting of evidence can be prevented. Point number 2 is that 161 statements or witness statements can be recorded in audio form. That would also help in certain extent, but we have to understand how the new technology is coming into picture, and how the deep fake videos and all that, and where they'll store these evidence is also a big crucial thing. There's a personal data involved. Does the police have that infrastructure to store these videos they are taking while they are doing search, or audios there while taking 161 statements? That is a concern. Apart from that, there are a few issues, but yeah, I think that would be a long discussion. We'll just end it here for some other time.
Sir, I heard that police had a lot of power earlier. The judiciary could not hold them accountable for investigation, for the work that they used to do. Did that situation improve? Does the judiciary have more power, more control over the investigation over the police right now under the new laws?
So I don't know, but I don't, in the sense, I'm not familiar with this line, the question you have put to me. But previously also a magistrate would completely have a power over investigation, while how the police officer is conducting an investigation. So till the police passes the baton to the judiciary through a charge sheet or a final report under 173, magistrate's role is zero. You should only approach a high court under writ petitions. Unless the police are not investigating properly, then you file a writ petition 226 and say that they are not properly investigating. If they have not properly investigated and submitted a charge sheet or a final report, then you can file a protest petition saying that they have not done investigation properly, or you can file a further investigation application under 173(8). So magistrate would role come at a later stage when the baton is passed from police to the judiciary. So till then, I mean, writ courts can have certain amount of overview on control on police, but as you know, everyone cannot approach a writ court in the state, right? Someone from Adilabad doesn't have any proper resources. How can you go to the writ court directly unless someone would come forward and file a petition for him? So in that way, yes, but now also nothing much has changed. It is the same process but different with different section numbers. I think yes, nothing has changed. I mean, after investigation, after the charge sheet has been filed, there are certain timelines which are given, which would favor the accused. I mean, within how much time you can file a supplementary charge sheet. Previously, to do a further investigation, you need not to take permission of the magistrate. It was a prerogative of a police officer. Now the police officer has to take the permission of the magistrate. That is one aspect that has changed. And to file a supplementary charge, there is a timeline. Within 90 days, you can file a supplementary charge sheet. Apart from that, I mean, magistrate I always tell my students when reading CRPC, first day I say them that CRPC is a conversation with power. There are six candidates to say it so: judiciary, prosecution, witnesses, accused, judiciary, prosecution, witness, accused, police, victim. These six candidates are essentially there in the CRPC, who are always trying to get more share out of criminal procedure code. Victims sometimes protest for their victim protection schemes are there, how victims' rights are evolved after 2013, right? Then prosecution, how they try to defend their cases, how they are trying to tilt the provisions. Same with respect to judiciary. So more or less powers are same. Nothing greatly has improved with respect to judiciary, the powers of judiciary. I think the timelines would make the situation little better, but I don't know how that would be. Unless the dust around the law settles, we cannot say how it would pan out. So we have to wait.
Sir, I think in 2002 the Malimat committee had recommended adversarial reforms, or was it?
So, I mean, we have a doubt whether we are adversarial system or an inquisitorial system. Adversarial, precisely, to put it simply, where a judge is neutral, he would just wait till the two parties fight and let the true flame come out of it. Whether the truth come out of it, he'll just be a mutual impartial spectator. He'll just guide the proceedings but not put fingers in the proceedings. When it comes to inquisitorial, especially with respect to erstwhile Soviet Union nations, it is mostly inquisitorial, where judge would rampantly put questions, guide the entire trial procedure. I mean, that is what inquisitorial means. Adversarial, prosecution has to prove the case beyond reasonable doubt. Inquisitorial, it is not to such an extent. But now India is both inquisitorial, quasi-adversarial, quasi-inquisitorial. We can say that. Because you can see Indian Evidence Act 138, 145, judge has powers to put questions at any stage, any time. You can 319, where judge can at any time invoke the powers to involve any other person as accused, or if he thinks that this person is accused, can issue summons to him. So there are a lot of such provisions in the CRPC also, which says that judge is inquisitorial, at the same time adversarial. So your question is with respect to, I mean, judiciary has evolved through case made law. Our judiciary is not a toothless tiger. They know what to do. They can evolve rapidly. They did that, and there are many case laws which would help in their enhancing their powers and as per their convenience. That is there. Ultimately, when you would have seen some movies also, I mean, this is my court, you can't do anything. That is still the situation in lower courts. So yeah.
As we all know, the financial situation for law students, new graduates, freshers in the field is very dire. What is your opinion on this?
Yes, I'm also facing it. What should I do? What should I say? But law for an advocate, I mean, frankly, after 1 year, I'm happy that the things have panned out differently, and I mean, I don't want to boast about myself, but that is, I mean, it's good for me. But I don't know how other, fellow advocates are facing the issue, because I can see that in my office only there are few advocates who are working for 10,000, 15,000. I mean, having 2 kids. I mean, it's not easy. I mean, what can I say? But it's highly rewarding when you can get your own cases. That's what seniors say. And at least my office at least allows to, take a few private personal cases. Other offices do not do that. So join an office which allows you to do that, where you can bring your own personal cases and take a share out of it while referring it to the senior, or at least your senior would guide you, to do your own cases and help you with that without expecting any money from you. Even if that is the case, then 10,000, 15,000 is fine, or 20,000 is fine. If not, there are other seniors, you are so burdened with their work only that you don't even have time to do other stuff or even read newspapers also, or join that office, because such offices pay you well. But if you are joining such an office and you are not getting money, at least you have to be happy that you are getting a lot of exposure, unless your senior is only putting you to the desk work, and that is a problem, big no. And you have to be lucky, and again, luck comes into picture, because you can't jump office like an intern, right? You have to stick there at least. Once you are in profession, you have to stick there at least for 1.5 years or 1 year. So you have to be lucky. Pray God while joining an office. Then with respect to the money, I think when we become, at least we should have the burden to change the things in the next generation. I think we should able to pay our juniors more. Down the line, after 15 years, we should have that. It is not something bad. You cannot accuse your seniors for not paying it, because that is how they learned, that is how they grew, and that is how they understood the things as they could. We cannot say that they are kanjus or there's. If you are doing it, you do it for your juniors. If you are getting 10,000 and you are able to, if you are assigning work to your junior, pay to him 2,000. He would be happy. If you are taking interns, pay to them at least something. In all my 5 years, I did not even get paid even a penny for my internships. This is the sad truth. Unless only for one it's not an internship, but Rashtriya Uchchajata Shiksha Abhiyan, it's a UGC program where I got selected. They paid, central government scheme paid me. Apart from that, no other office paid me. I even worked for 2-3, I can't name them, 1-2 senior advocates. I cannot blame them, because that is how the office is. Maybe they might be having a perspective that Niku, it is only you should be grateful that I gave an opportunity to you. Some might having that perspective. So you have to change your perception and accept others' perspectives also.
So the second question is, why are the national law universities having such high fees?
Is it states does not fund, generally does not fund these NLUs. So they are kind of a self-financed courses where, ultimately it is this, Naman. You can see university, Usmania University, right? Let's say if every student is paying 2 lakhs, you can expect the quality, because no teacher is willing to work at 30,000, because you don't know the plight of assistant professors. Newly joined assistant professors who does not have Harvard, Oxford behind their LLM degrees, or their payment is 30,000, 25,000. They have to stay the entire day, take 3-4 classes. It is very bad looking at them, looking at their issues. So CLAT and NLU is an elite institution that you can take for granted. Only students who have good financial background, students who studied at good CBSE, ICSE schools or colleges can only crack CLAT. It is very difficult for a SSC state syllabus students to crack CLAT, because the question paper pattern is such a way. For us to get at least below 1000, below 500 is a big achievement, and you should not look down upon yourselves. If a student, 18-year-old guy from a state syllabus whose English teacher only teaches in Telugu, comes to the classroom and teaches in Telugu, you should not feel bad, because I came from that background. I understand. Even in my entire college, I could not, the first year I could not even open my mouth and speak in English, because I was very afraid and conscious. My friends helped me in picking up English, but this is not, and I am grateful for them. You can't have that peers, everyone can't have that peers. So the issue is, CLAT is an elite institution. You can't question that, because you can see the even coaching institutions, they are charging like 60,000, 80,000 for what? Weekend 2 classes. It's insane the amount students are paying it, because I thought in such institutions I know how much they are paying the faculty, how much they are looting, taking from the students also. But education has become a business. You can't question that. I mean, that is the issue, problem, and there are very few institutions who can maintain the standard as well as charge less. There are very few, and I need not to name the institutions also. There are very few. In our state only, just tell me, while I studied my undergraduation, I paid 2,500 per semester. Now where can you expect that 2,500 rupees per? I completed my LLB with what, 25,000 hardly. So you can't expect with 25,000 those who are paying 20 lakhs fee and their curriculum, their rigor, how much you pay, how much you get. That is what it has become.
Sir, follow up to that question, the like education, the legal profession, some of these fields, professions from Consumer Protection Act. What is your opinion regarding this? Education, I think, in a landmark judgment, was kept out of the Consumer Protection Act. They have become businesses, as you say. But why is that they are not considered?
I think in the same judgment you are referring, Supreme Court has also pointed out that medical field, especially doctor's profession, should also be excluded, and it was referred to a larger bench to reconsider it. But as a matter of fact, if legal profession is included in consumer protection, I mean, without going into the depths of, because I did not have the chance to completely read the judgment or analyze on that particular aspects, but at the outset I can say that it would create few problems among the legal profession itself. I mean, this might be a very preliminary view, but which I might regret later, because I don't have the complete depth of the particular aspect you have questioned me. I think, if lawyers, I mean, especially with profession of law, there are a lot of things that, the system is so bad, you can't even imagine that to get a favorable order is a very big thing, that you must understand it. Because after doing all the 7 moot courts, I thought it would be a one-day batting matter in the courts, but it is not like that. The opposite counsel should be ready to argue. The judge should be ready to listen. Even to file a case, there are a lot of things which go behind filing a case. There are a lot of adversaries. Everyone is ready to fight against you so that you will not get an order in your favor. So getting an order is difficult. And if let's say I am for accused, he gets convicted, who would you blame? Ultimately he'll blame me, right? Because my lawyer was not right. So every losing lawyer, a case could, if let's suppose a judgment comes in favor saying that advocate should be under consumer protection, so that opens a Pandora box. Every losing lawyer, there would be a case, unless there can be a threat also, which can say, unless you don't file an appeal with lesser fees or with no fees, I would file a consumer protection case. That would imagine the pendency, the cases, how many cases would be filed and the level of pendency it would, because lawyers would only be filing the cases, right? Your fellow lawyers would be filing the cases, and they would be happily ready to file, because we are lawyers. We want not just cases, but we are bound by Bar Council of India Act and rules and our professional ethics, that we have to take any brief which is more legally right. We don't go to such an extent that morally it is good or bad, but we have to take it. We'll take it. We'll file it. This is a vicious circle, and that is one reason I think Supreme Court might give some beautiful, you can color the world in a beautiful paint, but ultimately this is the problem, crux of the problem. I feel this is a preliminary understanding. Maybe I can get back to you with a much better answer once I read upon these. Especially a few of my seniors wrote articles on these issues. So if I read them, then maybe I could be in a much, because I didn't have any counter perspective till now, because I never spoke to with anybody on this issue. So yeah.
So sir, the next question would be regarding the reforms in judiciary. What do you expect? What are you hopeful that they will be introduced? What are you looking for in the reforms?
I think I'm too small of a guy to comment on judiciary and reforms. But at the outset, I can say the strength, obvious answer, the strength of the judiciary has to be increased, because population versus number of cases and the judges which are faced again, they're working under a lot of burden and stress. That is one major thing. Then diversity, especially collegium system. I think collegium system should go, and like South Africa or Judicial Appointments Commission, or at least a new NJC should come into picture, and appointment, there should be diversity in appointments, because we can see that judiciary is only under the hands of few elite class. You can name the caste also, which I don't want to do. Few my uncle is there, my aunt is there, my aunt is Chief Justice, so on and so forth. There's a survey also, there's a survey also which says that 34% in Uttar Pradesh, which says that 34% of litigant lawyers are somehow related to the judges in High Court. So that is an issue. And nepotism is there in judiciary. I'm not talking in advocacy, that is also there. But still, now we are focusing on judiciary. So that should change. Appointments should change. It should include wide, diverse varieties of this thing. And then more judges. Then having a bench in a Supreme Court bench in South India also, because there's another survey which says that only North Indian states prefer appeal to the Supreme Court much more than South. I think it's Rajiv Dhawan's article only. I am failing to remember the article's name. So yeah, that is one issue where another bench should also be established for the accessibility. And then more and more technology driven should be there. Now also I appear in high courts, I see that judges are kind of reluctant. They'll ask us to come, especially when they look at a junior's face, why are you appearing online, come, why can't you come? These are some passing remarks I can see which were passed against me as well. So that is one thing, more acceptability to virtual mode of hearing. That would save a lot of costs, especially to get justice. We are spending a lot. You can't expect an advocate to file a high court writ petition under 10,000 and you should travel for the same writ petition 10 times. It is not possible. It is not actually possible. That is the reason why few things have to be adopted. AI should be introduced more, so that a kind of a, I've heard some, I think in second year or third year when we are writing an article on it, so we came across a paper which says that a judge can even predict to what extent a person can take an adjournment, whether he'll take an adjournment or not. If he wants to take an adjournment, he can just create a software where he can send him just previous day, I want to take an adjournment. If judge wants to accept, he can accept. If the AI, it's so powerful now, if you can upload the both the files of petitioner and the respondents, and if the AI can generate a solution, and on that if the judge applies the judicial mind, then it would be much easier. Lot of time would be saved, especially thousands of pages. You can get a quick synopsis if you can upload in AI. And AI, obviously I think that would happen. We would only be a puppets in the hands of AI, applying a little knowledge here and there. We'd make some corrections. I've used AI, so it's not. I'm even drafting petitions with the help of AI. So it's easy. Even it would be useful for judges also. And the it might be difficult at the trial stage, but that would also it would be possible. Everything would be possible in very soon. A decade more, we are ready for many changes, unexpected changes. We have to be ready for all the adversaries. Yes.
Sir, follow up to the collegium system suggestion which you made. Sir, wouldn't the government pick and choose, people who they think they are pro-government pro-government judges, etc. If the NJAC or an appointment commission is based, what is your opinion on that? Because the biggest litigant is the government, 50. Then how can they be a party in choosing the people who would judge?
So let's understand. I mean, if you have time, then I'll explain. I mean, let's understand before 1993, right? Second, before SP Gupta, yes. Before then Sakal Chand Seth versus Union of India, then SP Gupta versus Union of India. Then we have Supreme Court Advocates on Record versus State Union of India. Then we have In Re Presidential Reference 1999, where collegium word was firstly introduced. Third judges case. Actually, it should have been called fourth judges because they have not included Sakal Chand case. So till that, it was so. After SP Gupta, that means Supreme Court Advocates on Record. So they've interpreted consultation as concurrence. You know that. You know all that story. I need not to tell you. But for benefit of doubt for our viewers, I'll tell that. Before that, it was only consultation. SP Gupta, there were two judges, Justice Bhagwati and Justice Krishna here. They've beautifully elaborated saying that Justice Bhagwati's judgment, you have to read it. He says one thing, that there is no hierarchy in the constitutional functionaries, especially SP Gupta was also on an issue of transfers also. There is no hierarchy with respect to Governor, President of India, Chief Justice of the particular High Court and the Chief Justice of India. The Constitution does not mention any hierarchy. Even Krishna here says that if there is a malified intention, then the same High Court can stall the transfer. He laid a law to some extent. But before SP Gupta, before SP Gupta, you see, even in Constituent Assembly debates, Dr. B.R. Ambedkar also said that the word consultation is only to have a check. The President would only be appointing. If that is the case, then what was the problem for the first 20 years of the Constitution coming into picture? All brilliant judges. Krishna Iyer was a government appointee. He was a Communist Party leader. Later he got elevated to the Supreme Court. Bhagwati was also government appointee. He was close to Congress government before that time. Appointment was made. But there is a backlash for this also, because we have seen the dark period of emergency, how emergency took into picture and how A.N. Ray was superseding Justice Hegde, Sheelath and Grover. They were superseded by A.N. Ray, and subsequently after ADM Jabalpur, H.R. Khanna was superseded by H.M. Beg. Right? So immediately H.R. Khanna resigned. So there is a level of interference. It's there. You cannot. And to interesting fact, when all this happened on the floor of Parliament, I think Mohan Kumara Mangalam, who was a CPI leader and then later joined Congress, supported Indira Gandhi's move of appointing A.N. Ray, superseding A.N. Ray. He said four things. He said four things. One, the tenure of the Chief Justice period is important, because at that time he gave a quotation. He said that the maximum tenure is 2 years. The time. Now the recent survey says that 11 months. What would a judge do in Chief Justice? What administrative reforms he will do in 11 months? This is not saying government should appoint. I'm just saying, giving you some facts to think about. So let's say B.V. Nagaratna is Honorable Justice B.V. Nagaratna would be the first woman judge. What is her tenure? What impact can she bring? So that is a problem. And second thing, he says that we cannot expect a judge to be a politically innocent. Obviously he would have his political ideas and ideologies. You cannot expect that. You cannot separate it. And to get into higher posts, especially in judiciary, you need to have certain push, without which it is not possible. We are not living in an ideal world where only merit is considered, right? There needs to be some push. So And subsequently all the authors say that the greater the level of power the judiciary has, after especially after 1970s, judicial review and judicial activism was at peak. So judicial power expanded to a lot. So when the powers are expanded, the appointment also becomes more crucial. So that is the reason why government more and more started influencing it, because judiciary became more and more active. It lays law on in national highways, liquor, crackers, kites, everything. Nothing is under, everyone is under judicial review. Even you put it in ninth schedule, they say ninth schedule is also judicial review. They say judicial independence, that is also judicial. Speaker, judicial review. What happens in parliament? Judicial review. Everything is under judicial review. So appointment becomes very crucial, because that is the major. If I can get my candidate there, then I am sorted. So now striking down a law which has not been implemented is a problem, because Parliament's ultimate power, under ultimate wisdom, under constituent power, under 368, they had made a constitutional amendment and made a law of NJSC. Without trying that for a moment, how can you strike it down is my question, my problem. At least you should have tried it. You tried electoral bonds. What happened then? Why didn't you stall at the first instance? You could have tried it. We would have seen 5 years mein to kuch antem what would happen? Democracy would fall. It is not that easy in 5 years, right? At least you should have tried it. That is one major concern I have. Secondly, I read Justice Chalmeshwar's dissenting view in NJSC judgment. I loved it. He's a Telugu guy. I loved it more also, because he says two things. Affecting basic structure is different. Destroying basic structure is different. Affecting is so the whole he says that judicial primacy is different, judicial independence is different. You cannot say judicial, if there is judicial primacy, then only judicial independence. In appointments, you cannot say if only judiciary has primacy, then only independence would be there. It is not a boys club where I say only my guy I will elect someone, or I am only accountable by my colleagues to my colleagues. But he also answered another question. Judges are accountable to bar members also. But to what extent are judges accountable to bar? Is it a joke? If I practice before a high court judge, he would be accountable to me. He may be accountable as a group. But to what extent can we remove a judge, a bar member? It is, impeachment, the removal of judge proceeding is different. That accountability, I don't think it is possible. So, affecting basic structure is different. Destroying basic structure is different. This is something which affects basic structure, in my opinion, to a certain extent, which can be cured later, slow by slow, step by step. I think that we should have tried somewhere. You see South Africa's Judicial Appointments Commission. There are 25 members in the collegium system. Even a professor from a prestigious law university would also be there in the collegium. So why not try it? What is the problem? We should give a try. We should have given a try. That is what I say. And the collegium is also good. There are 6 members. Chief Justice, 2 senior most judges, Law Minister, 2 members appointed by Prime Minister, Leader of Opposition, and Chief Justice of India. And in one that there is a reservation. It is as diverse as it can get. So maybe some tweak here and there would have been much better. But I somehow don't find it logic. I cannot. At my age, I cannot think I can criticize the Supreme Court judges. But I find it is not correct in my opinion, in my humble opinion, if I have to say so. We should have tried Judicial Appointments Commission at least for 5 years.
Yes, sir. So I would like to end with one last question. What is your advice and suggestions for law students right now?
Advice and suggestions. I don't want to be because I don't want to sound like I don't want to. So enjoy every moment in your law school. It is a golden period of your life, especially 5IDC students. You won't get that time after you enter into litigation, because one such example, because Naman also started, interning, practicing this and that. We were planning this podcast from literally 6 months. We could not get a time to. He was busy, I was busy. It is not even possible, once you join the practice profession, you are a bonded labor, that is for sure. You would be extracted completely. You won't get the time. So make good friends in your college. Talk well with your seniors. Your seniors would help you a long way. They would refer you cases. They would give you advice when necessary. Right? Your friends would take dates for you when you are stuck in other court. Because if you ask another colleague advocate, he would charge money even for taking date, which I have experienced. So have good friends. Have friends in different different districts also. Never kind of stick to your own peer group. Have friends from different districts also. I mean, look at from professional point of view. They would refer cases to you. Then, I mean, true friendship is only found in the 5 years you get it. After that, I think it can be found, but I mean the chances are less, I can say. Be good with your faculty members. I mean, I am also a faculty, so be good with your faculty members. I mean, some of them might be nice and might help you. There are always so once you knock the door, they are always willing to help. The question is whether you knock the door today or after 5 years. That is the issue. You can knock it now. You can daily knock their doors. You can daily talk to them. They are happily willing to help you. They will help you also. Another thing is don't just read your syllabus, because law is very dynamic. Don't restrict yourself with syllabus. Read from variety of myriad of sources, from journal articles, from newspaper articles. Especially have a subscription for Hindu. Don't subscribe for Netflix. Have a subscription for Hindu or Live Law. Student edition, there's a discount. Go check out just now. There's a lot of discounts going on. Right? So do that. Have a subscription. At least you read an article once a day, once a week. Then if possible, have a deadline saying that I'll read 10 case laws per month. Do that. It would be helpful for your competitive exams also. Then what can you do? Do internships, write articles, participating in moots, getting out of your comfort zone, breaking the shell of fear, coming out of your own shell. That is important, because that participating in if I am talking to you like this, that is the sole credit I can give you is to the moot court and the judge who has scolded me in the moot court. I can give the entire this thing to him only. So participate, get scolded. Do that, all that things. Enjoy every day. 5 years are precious. Half a decade of your life is not a small thing. So that is what I have to say. Yes.
I would like to give special thanks to Praful Vaidya sir. So he has offered us his office location for shooting this podcast. So readily he offered it himself when I said that I was going to shoot a podcast with Pavan sir. So thank you sir for that. He has just inaugurated his new office and his new firm. So E Square LLP. Thank you sir.
An interesting fact. Actually, he is my student, but is more experienced in criminal laws and all that laws, and it was very difficult for me to handle. I think they are my first students. When I became JRF, they are my first students, first batch, and he was one such student who regularly came to my class, and then he interned with us in our office. So that's how I know Praful, and he's a very very talented, sincere, hardworking, everything. I mean, if there are any adjective that should go behind his name. Yeah.
Thank you sir. So thank you sir for this wonderful podcast, and we would love to have you for a roundtable podcast as well with some other luminaries, so that we can delve deeper into the fundamental questions of law.
Please tell me, because today you asked some questions which I could answer, so please tell me beforehand so that I would prepare and come, so that I can be wise in front of them. Thank you, Naman. It was a wonderful experience. It was a joyride all throughout the podcast. I didn't expect that it would be so smooth. Thank you, Praful sir, for this wonderful office. We got wonderful space, and to your team also. I'm so sorry I kept you waiting. Next time I would be before you on time. Thank you, Naman.
Thank you sir.
Thank you.